thank you for the opportunity of speaking today regarding forthcoming developments in building and construction in New South Wales. My name is Anthony Herron. I'm Special Counsel with Counsel, and we specialise in construction and commercial building matters in New South Wales and in other courts as well. The topic is topical because of the passage within the last 2 weeks of two key pieces of legislation in New South Wales, namely the first one of which is the Design and Building Practitioners Act 2020. This was assented to on the 11th of June. In addition to that, we had the Residential Apartment Buildings Compliance and Enforcement Powers Act 2020. That was assented to on the 10th of June. In addition to that, we'll be considering the report and recommendations from the New South Wales Legislative Council through their Public Accountability Committee, which, as at 30 April this year, prepared a series of 22 recommendations for the licensing, regulation and development for building and construction in New South Wales. Those recommendations are following from the two pieces of legislation which we've just discussed. Those pieces of legislation provide for the report to be prepared by the New South Wales Legislative Council Public Accountability Committee by 30 June 2022. What that means is that this space is certainly going to be an active one over the next couple of years. In addition to that, the recommendations cover such things as issues dealing with cladding, and New South Wales and Victoria, for example, have a different approach regarding cladding in terms of how it is to be done. In terms of a funding package, Victoria has a funding package provided. New South Wales does not, and I think prefers to let industry regulate the management of rectification of cladding issues. The Public Accountability Committee also has made recommendations dealing with mandatory inspections for building projects 2 years post the issue of a development consent. Also dealing with such things as appointing a strata commissioner who will be empowered to deal with specific issues relating to strata buildings, building defect and design issues and compensation, particularly where they relate to the lack of insurance, it's home warranty insurance on those particular issues. The last thing that these recommendations cover relate to the issue of private certification. Now, New South Wales currently, certification is managed by private certifiers on the whole. Some larger developments still have certification carried out by the local council, but the last 2 weeks events have said to me, and certainly the Public Accountability Committee's recommendations, indicate that they are looking at a revision, in other words, an amendment to how buildings are certified in New South Wales, and possibly referring those back to regulation by local councils. You'll see on the slide to reference to two particular instances, a report in Sydney Morning Herald on the 18th of June, which deals with an investigation of an accredited certifier concerning a project at Auburn. That has hit the headlines both on the ABC News and in the Sydney Morning Herald, where David Chandler has commented that that particular building in Auburn was the worst building that he has seen. Quite high praise, or damning praise, for a man that's been in the industry some 40 years. So that itself has attracted considerable media attention. In addition to that, we have a further report on the 15th of June from the Sydney Morning Herald concerning a further investigation by Fair Trading into the licence and appropriate inspection arrangements and whether those were attended to for a building which sits next to the infamous Mascot Towers, which is currently empty, and that has been the subject of considerable litigation. The building next to that apparently has issues of relating to its construction, and there may be a link between the design and building issues which have been discovered in the building at Mascot Towers as a result of the earlier development which had occurred. occurred with the building next door. All of which says to me that this space is one of considerable movement. It also says that there will be some considerable emphasis on registration, compliance and enforcement, and that is really the subject of our discussion today. This slide sets out in rather in a big picture perspective two issues. What it has said to me is I've prepared this timeline which deals with key events which have happened throughout 2017. You'll see there 2017, 2018, 19 and 20. I've highlighted certain issues in red to bring those to your attention. What I want to do is, one, draw to your attention these key events which have happened, principally, for example, with the Grenfell fire in June 2017 in London, which unfortunately resulted in the loss of some 75 lives. That followed began a series of government responses, both at a federal and at a state level for each state government, where they began to investigate building product safety. So this result was really the genesis of the investigations. Those, of course, were really preceded by an investigation by Michael Lambert, who prepared a report commissioned by the New South Wales Government in 2015 concerning regulation, inspections and appropriate licensing of various building industry officials. That, I think, has set the tone for the last 3 or 4 years investigation and compliance enforcement issues in New South Wales and how the government has responded. So we have this issue in 2017, a serious fire in Grenfell. We then have in December 17, the New South Wales Government introducing the Building Products Safety Act to ban unsafe building products, principally to capture such things as aluminium composite panelling. That has certainly been found in the preliminary investigation stages through the Grenfell fire in the United Kingdom to have played a significant part in the spread of the fire and loss of life. Going down the page, looking through the events of 2018, one of the principal issues that has emerged is the preparation of a report prepared by Bronwyn Weir and Peter Shergold concerning the Building Confidence Report. That was really an attempt to try to understand and bring to light, make a series of recommendations concerning better compliance, enforcement and registration of building practitioners across Australia. New South Wales Government has responded to that by preparing its response. For example, in August 18, we have the preparation of a ban by the New South Wales Government concerning aluminium composite panelling of more than 30% by mass. So that, I think, is one of the New South Wales Government's responses to issues with unsafe or defective building products. Further on in New South Wales, at the bottom of the page, I've highlighted the La Crosse building in Melbourne. The builder there was L.U. Simon, and those proceedings began in 2018 in relation to a fire which happened at that building in 2015 and resulted in significant damage to the building and unfortunately no loss of life, but that resulted in a subsequent court case which we'll briefly consider. In December 2018, another significant event which brings to the public attention the issue with defective building and building design and product relates to the Opal Olympic Park building, where the builder, it seems from the subsequent investigations through experts commissioned by New South Wales Government, through the University of New South Wales, discovering building defects and engineering and design issues in the Opal Tower. The last word on it, I think, is that that building is occupied, but the builder, I think, spent in excess of $20 million trying to rectify a series of those particular issues. So again, this is just another signpost of an important event which has brought to the public attention issues with the building and construction industry. In 2019, a couple of key events occurred. I've highlighted there a fire which happened in February 2015 to the Neo 200 building in Melbourne. The builder there was L.U. Simon. So here we have the same builder as was found in La Crosse building. Neo 200 was a fire which involved where there was involvement of aluminium composite panelling. Was said to be the not the cause of the fire, but at least regarded as almost like an accelerant because of the aluminium composite panelling that had been constructed. 25 days later, on the 28th of February 2019, we have a significant judgment from the La Crosse fire, and that was prepared by Justice Woodward from the Victorian Civil Administrative Tribunal. His judgment was a landmark decision. What that found was that the builder, L.U. Simon, had breached the Building Code of Australia. It was also found to be in breach of the building regulations, and it had been responsible for the choice of the aluminium composite panelling. That said, the judge found that the builder, L.U. Simon, had not failed to exercise reasonable care. What makes the decision a landmark one is that it really is one of the first decisions in Australia which deal with the effect of the aluminium composite panelling. The judge found on the issue of proportionate liability that the surveyor, the architect and the engineer, fire engineer, were responsible for, or each played a part in the aluminium composite panelling and the cause of the fire. Ultimately, the judge handed down a decision of damages in excess of 5.7 million in favour of the Owners Corporation. The balance of the claim, and what he did was he apportioned liability between those three other parties. That decision is the subject of an appeal in the Victorian Court of Appeal. It was meant to have been heard in June, or foreshadowed to be. I've been trying to keep a tab on the hearings of it, but thus far not found it. But that will be an important landmark. Turning our attention to the current times in 2020, where, and which we will be discussing today, those two pieces of legislation. We have the Design and Practitioners Bill, which was introduced in October 2019. That has now become an Act and assented to on the 11th of June this year. And then we have the Residential Apartment Buildings Compliance and Enforcement Powers Act. It's quite a mouthful to say, was assented to on the 10th of June. That is a far-reaching piece of legislation which we'll discuss. So I think we can see that the events of the last 3 or 4 years have been significant in terms of how the landscape has changed, not in New South Wales but in Australia, in terms of registration of relevant parties, compliance and enforcement, and at government having their response, which is designed to try to provide increased consumer safety and also recompense in terms of what damages would be available if there is a finding of various design defects in design and or construction. This slide deals with the issues of the findings from the New South Wales Legislative Council through its Public Accountability Committee, which has considered recommendations leading to the passing of these two pieces of legislation which we're going to consider. Before it decided to, or just reaching its decision in terms of passing legislation and considering debate on the two pieces of the two acts which we're considering, the Public Accountability Committee took a number of soundings and hearings from public stakeholders. I've summarised those findings there, but they're not particularly favourable, probably not unknown, in terms of there being deep structural failings with the New South Wales construction industry, a lack of consistency in registration and licensing by various practitioners in New South Wales. We have problems with phoenixing and liquidation of both builders and developers in New South Wales, which has caused a lack of recompense for consumers and parties that are landowners, principally people who have invested life savings and are either landowners and or investors who have been found to be without recompense. There's finding also that unprincipled developers have set up their regime of developing land, selling it, then deregistering the companies that they have done that, and they've also found that the New South Wales regulator responsible to registrate, to licence and consider the ongoing registration of various parties has not been doing its job. A lack of transparency and visibility in terms of understanding what's being built, when it was built, the parties that are involved, and also seeking to enable proper recovery, finding that many times the key documents such as construction drawings and plans, the identities of the parties that have carried out building, the identities of the developers who've played a part in financing the various projects are not clear. For example, I've had a number of cases where we're acting, for example, for owners corporations in large developments, that various key documents concerning the plans and drawings have been kept by an owners corporation committee. On the change of the committee, the member has, or the particular committee person, has decided to throw out various pieces of those key documents and drawings, which has severely hampered the subsequent owners in trying to seek adequate recompense and recovery. These are some of the issues that have been found by the New South Wales Legislative Council. The last issue that I want to comment on in this particular slide relates to the issue of insurance. Without adequate insurance, such as home warranty insurance or professional indemnity insurance, there is no functioning system to provide a backup or a safety net for people who have suffered loss as a result of defective building product and or defective design. So these two pieces of legislation are designed to try to supplement these shortcomings in the industry. In summary, the first act we're going to deal with, the Design and Building Practitioners Act, was assented to on the 11th of June, as we've said. It does set out a system of registration and provision of declarations for design and building practitioners. Those registration and compliance declarations, however, will not take place or not be applicable until next year. In other words, till the 1st of July 2021. The key piece in the legislation, however, which provides for a duty of care for by developers owed to landowners, will, however, take place on the commencement of the Act. It's just that the issues of registration and compliance declarations, however, won't take place until July next year. As you can see from the slide, a standard of care for the duty of care is set out in terms of trying to explain to landowners what the standard of duty of care will be, and which is owed by building practitioners, building designers, and engineers involved in these particular projects. The Design and Building Practitioners Act applies only to multi-unit and multi-storey residential apartment buildings. The regulations, which have not yet been drafted, may provide for the applicability of this legislation to other style developments. But at the moment, it only applies to multi-storey, multi-unit developments, Class 2 buildings where you have 2 or more occupiers in place. It doesn't apply to existing work or arrangements, only applies to new work or arrangements entered into after the commencement of the proposed legislation. Let's look at the key players. The key players are important to understand who is involved in and caught up in this new legislation. We have the building practitioner on the right side. Principally, they will be the person responsible for carrying out the building work. Building work has been expanded or has been to include design, but from the building practitioner's perspective, they are responsible for building the work, for carrying out construction of the building elements. Building element has been taken from the definition set out in the Home Building Act in relation to building work, including building elements, waterproofing, fire safety, and it really affects the major structural element of a building. The building practitioners owe a duty of care to take all reasonable steps to ensure that the building work they do complies with the relevant BCA. They do have defence, which we'll set out a little bit later. They are also required to have adequate insurance. The next key principal player is a principal design practitioner. So as we said earlier, this legislation seeks to broaden the scope of the umbrella by which you have responsibility owed not only for building work, but building design. These building design practitioners, for example, architects, are responsible for, building principal design are to coordinate the provision of design compliance declarations. By that I mean, they have to ensure that a design practitioner that prepares a regulated design issues a compliance declaration for each building element as part of the building. So we have the compliance declaration issued by the design practitioner. The design practitioner is also required to be appropriately registered for the type of work for which they issue a compliance declaration. So it's then the responsibility of that design practitioner, again, to have appropriate insurance that matches the work that they are doing. The third major player in this is the principal design practitioner. So their role is to coordinate the provision of a design compliance declaration. So they have to ensure that the compliance declaration for each building element is being provided by a registered design practitioner, and they also have to ensure that that design practitioner's registration is appropriate for that declaration for which they are making under the legislation. Those principal design practitioners would also have to have appropriate insurance. The legislation talks about if a principal design practitioner is engaged. I would think that unless you have a larger project, I would suggest that the building practitioner would work with the design practitioner, who's more likely going to be, for example, an architect. For example, if you have a larger project, however, you may have the involvement of a principal design practitioner who's overseeing the registered designs, making sure that each of those has a proper and appropriate design declaration. The Act also makes provision for two other key parties: a professional engineer. So in the original bill, which was flagged in October last year, it sort of hinted that professional engineers might be caught up, but now this legislation, which has been amended after discussion and taking various soundings from stakeholders, includes specific reference to a professional engineer. The Act makes clear that that person is responsible for the design, the production, operation, and engineering work, which involves a specialist engineering scope. That sort of person will be caught up or regarded as a person that's a professional engineer caught up in this legislation. Again, they will need to be registered. They will also need to be insured. In other words, have appropriate insurance. The fifth category of person which will be caught up in this legislation is the specialist practitioner. The Act does not make clear what specialist work is, but could I suggest to you that by reference to the New South Wales Office of Fair Trading, it issues, as you know, licences for various contractors and various levels. So it issues a contractor licence for people that are responsible for carrying out building work, a building practitioner. A specialist practitioner may include a person that is responsible for building and design work concerning electrical, air conditioning, plumbing and other work that they may be regarded as a specialist practitioner. They will also need to be appropriately registered and hold appropriate insurance. So they are the key players. What are the key elements involved in this legislation? The first one we'll look at relates to design practitioners. Now, I think we've covered some of this in the earlier point in our slides. The key things are that they are to be registered, that they are to issue a design compliance declaration. In other words, for every design that is prepared, they will issue a compliance declaration that the design will meet or satisfies the various Australian standards and or the Building Code of Australia, or it might be for the National Construction Code where you have a performance solution which has been prepared. So we have a design practitioner who's registered. They'll issue a compliance declaration that each of those designs will meet the relevant Australian standards. The design declaration will also capture their providing a declaration covering variations. So this is quite common in building where you have an agreement between the parties that there be work which differs from the original agreed contract. Variations leads to a lot of issues and disputes. Variations will also be required to hold or to be covered by a compliance design declaration prepared by the relevant designer. The important thing is that they also must be indemnified. In other words, appropriate insurance needs to be in place, and that this has got to be appropriate for the type of work for which is being done. There's also a provision in the legislation whereby if a company is carrying out or preparing the design and preparing a design compliance declaration, the directors might also be individually liable for a failure to comply with the legislation. So again, what this piece of legislation does is it seeks to go beyond or behind the corporate veil and make directors of those relevant parties that are carrying out design work as a corporate entity personally liable for a failure to comply with the legislation. So that's the design practitioners. The legislation also makes provision for the role and a comparison between the responsibilities of the design practitioner as opposed to the building practitioner. There are differing standards of care which are owed by these parties. Briefly, we'll look at these. The important thing for designers is that they prepare a regulated design. It's defined in the Act to include cover building work, so it will cover work involving building elements, it will cover major structural work, and will also compose or rely on or capture performance solutions for prescribed classes of work. So we have a regulated design which is going to cover building work. We have a registered building practitioners. They again will have to complete a declaration that they have carried out their work in accordance with reasonable care. So the building practitioners will have to take all reasonable steps to ensure. They also have defence under sections 25 and 26 of the Act that their work has been carried out reasonably reliant on the designs and plans that they have received. Quite similar to the current Home Building Act, which says that a builder may have a defence in relation to building work where there is a claim for building defect in relation to where he's able to say or establish that he's reasonably followed the designs that have been prepared for him. I'd suggest to you, however, that for the designers, there is a higher standard. The designers are required in mandatory terms to comply, that they must comply except with reasonable excuse. So it seems to me the legislation imposes an increased or a higher standard of care for parties that are responsible for preparing and or coordinating design and or design declarations. I'd suggest to you that this is a major change to the legislation, which principally has sought to capture the responsibility of both design practitioners and building practitioners. We spoke earlier about the duty of care, but the Act goes into some detail in Part 4 as to what is meant by the duty of care. It's not going to cover all work. What it will do is it's designed to capture work for building defects. So firstly, it's meant to provide coverage for owners of the land. It'll be the owner of the land. The Act also makes provision for this to include an owners corporation, an association for a community or a precinct or a neighbourhood. So they are owed the duty of care. The person that owes it is the person that is carrying out the construction work. By construction work, the Act specifically expands that not only to include construction work, but also design work. So this is where the duty of care owed to owners and will capture both the design and the construction work. The legislation also makes clear that the actual duty is to avoid economic loss concerning building defects. There's no cap on the damages that may be awarded for economic loss. That's a major boon in the legislation from a consumer perspective. So, for example, in the Home Building Act, there's a provision for the damages to be recovered for defective and or incomplete building work. Similarly, with the Design and Building Practitioners Act, there's a provision for damages for economic loss for rectification. This piece of legislation makes clear that there's no cap on the damages which may be awarded, which is significant. In other words, defective work and or design work which results in economic loss, that will entitle the relevant owner to make a claim. When you talk about a duty of care though, then the first thing is that you cannot delegate. So from a construction contract setting, the builder cannot delegate down the line to his subcontractors responsibility on their part to take responsibility for work that he is responsible for. The Act says no to that. It says no to parties delegating their rights, in other words saying we're going to agree to contract out of our rights, so the most powerful person in the contract setting will be able to pass their responsibility to other parties. This legislation says that cannot be done. What the Act also makes clear is that these rights of a duty of care for economic loss are in addition to the other statutory rights and duties set out in other key pieces of legislation, specifically the statutory warranties set out in the Home Building Act in Section 18B, which make provision for 6 sets of statutory warranties in relation to the work and the building product, that they will be new, they will be fit for purpose, and they will be in compliance with the relevant standards and codes. Can I show you an issue with limitation periods? Just a point of comparison. Let's look at limitation periods. When I say, if we do it by comparison, the Act specifically references the Limitation Act and also references the Home Building Act. By that I mean, let's look at this as an illustration. On this slide, we had the limitation periods up top. On the left-hand side, we have the comparison with the different pieces of legislation, which we'll briefly discuss. And on the lower horizontal bar, we have the number of years for which you might make a claim for building defects and or design defects. Starting with the Limitation Act, 1969, there is a 6-year limitation period for making a claim for contract and tort from the date of completion of the work. The Home Building Act gives you 2 windows of opportunity to make a claim. For 2 years post completion of the work for minor defects, 6 years from the construction or completion of the work for major defects. So we're dealing with major elements of a building used that are essential for its stability and which are vital for public protection and essential to human life. So 6 years. By way of a comparison, the Environmental Planning and Assessment Act there provides what we call the long stop provision of a 10-year limitation period, which finishes or starts from the date on which the building work is completed. That is probably the end point for making a claim for building work and building defects. By way of comparison, the Design and Building Practitioners Act, I've flagged a couple of different scenarios that will apply. The first is this, that the Act is retrospective. So the duty of care will operate from the date of assent to the legislation, which was the 11th of June, and it will mean that there can be claims for compensation which go back 10 years prior to the legislation commencing. So it may allow an opportunity to claim building defects and of design issues under this legislation. I would suggest that, for example, that would need to be actively considered. The Act specifically refers to there being a provision for proceedings which may already be commenced in relation to building and design defects. What I think the Design and Building Practitioners Act seeks to do is expand the role or expand the consumer benefits open to parties, that's landowners that have suffered a loss as a result of defective work of a design and or construction nature. One thing that I also point out, and we might go back to the preceding slide with this, some of the effects of this Design and Building Practitioners Act are this. You have an increased number of potential defendants that may be caught up as or as parties to potential legislation. This is because the definition of construction work is significantly expanded to capture not only construction work or building work as traditionally known, but also to capture design work. That's the first thing, liability. We have a second issue with multiple defendants and wrongdoers, as seen as an example in the La Crosse decision, which implicated not only the builder, but also the designer, the fire services engineer, and the certifier. So I'd say to you that using La Crosse as an example, this legislation that we're just considering actively considers there being multiple defendants and wrongdoers that may be regarded as concurrent wrongdoers in a similar way that La Crosse found. And so that means that any person, any lawyer considering commencing proceedings for design and or building defects would need to consider that there would or there may be more than one course of action to seek to provide recompense to a person, a landowner, that has suffered a loss. The third issue deals with the differing limitation periods, which we've discussed a little bit earlier, but it's relevant this way. Under the Home Building Act, you have a 2 and a 6 year period for minor defects and 6 years for what we call major defects. Before this legislation came into being, with the effect of the decision from Brookfield Multiplex from the High Court, 2014, that said that there was no common law duty of care owed by a builder, constructor, to a subsequent owner. This legislation, the Design and Building Practitioners Act, really expands the role of a duty of care. It says that not only a building practitioner, but design practitioners will also face potential liability excuse me, in relation to defective design and or building defects. The legislation specifically makes provision for the retrospectivity of it. So in other words, it may permit a claim to be made 10 years within commencement of the building work. Now, that is a significant potential liability opening up for design and building practitioners going back that far. That's specifically referenced in Schedule 1, Part 5, Clause 5, or it may be 10 years post the, within 10 years after the loss became apparent. But let me make this point. A loss becoming apparent of the type of defect which is the subject of this legislation might not actually become apparent until several years after the building work has finished. Several years after the owners or residents have assumed occupation of the premises, which potentially means that a 6-year limitation period, which you might expect as being the outside claim period for commencing proceedings for a major defect, as we'll call it, could actually expand to much longer than that, possibly 8 to 9 years post construction or completion. Something to bear in mind when you look at the piece of this legislation. And I think that was part of the thinking behind the legislation. In other words, to provide a greater width of compensation or availability for claims. Part of the issues that we've already highlighted with the legislation also deal with a differing standard of care. So depending on the assessment by the relevant expert about the nature and extent of the defect and what that is, with the building practitioner having to take all reasonable steps, as opposed to a design practitioner having a mandatory obligation to ensure that the design declaration and compliance meets the relevant Australian standards in all BCA. That is the reason for this slide, where I'd suggested that a little bit of the unknown about the duty of care and the width of that needs to be considered when we're looking at the Building and Design and Building Practitioners Act. Some of these issues we've dealt with, but let's have a look at the last few points on the applicability of this legislation. Proportionate liability, yes, that's an important one to consider. If you're acting for a builder and or a developer, consider that particular issue. If you are, based on the Lacrosse decision, where the builder had expectations based on its contracts and subcontracts with the designers, the certifier and the fire safety services engineer, each of those was found to have failed to have honoured their obligations in a contract setting to the builder. On that basis in Lacrosse, the court found that they were considered to be a concurrent wrongdoer with the builder. Part of the reason behind the appeal from those parties that were found to be responsible as defendants lies in the finding that despite the finding of the VCAT decision of Lacrosse, which pointed the finger to the builder, but then failed, and also found that he did not fail to exercise reasonable care, but also the finding that these other parties, the engineer, the fire safety services and the certifier and the architect, had all breached their contractual obligations. I'd suggest to you that increasingly we'll see building defect issues and design issues involving multiple defendants. Requires good record keeping from a developers and contractors setting, understanding what was requested to be designed, what correspondence flowed during the course of construction relating to responsibilities for design, particularly if you are responsible as a builder for a design construct. Means that you have assumed a greater responsibility. Also, I'd suggest to you that the understanding of whether particular liability lies will be important, and this can will be determined by appropriate expert evidence. It's important to understand at the outset when we're advising either an owner and or a developer, a constructor and or designer, firstly, what is the extent of the problem? Where are the defects? How long they have been there? What are the nature and location of the defects? To understand whether these are something which are a maintenance issue. On the other hand, they may be of a lesser nature in relation to, so they might be found to be out of time. If they're not of a major structural issue, falling within the definition of the Home Building Act, and regarded as a serious construction defect, the 2-year limitation period may be expired. On the other hand, if they're found to be more of a major issue, then they may permit a claim to be made for the major design claim for responsibility, which would bring them within the 6-year period. The importance of suitably qualified experts at every turn is important to determine liability, both from parties acting for owners and also designers, builders and developers. Lastly, the issue about insurance. This Act mandates registration and insurance by both design and building practitioners. But at the present time, following La Crosse and in view of the findings with the multiple issues arising in relation to aluminium composite panelling, the insurance market has been thrown into flux. In other words, there have been a number of claims where involving aluminium composite cladding where various parties have not been able to claim on their professional indemnity insurance. That issue is still not resolved, and I suggest that the effective passage of this legislation as a tool to try to aid enforcement and recovery for owners and people suffering loss has to go hand in hand with adequate pricing and insurance to understand precisely what the risk is that the insurers are to take on, whether the cover that they are providing is adequate, and then to understand the pricing of that before they go to the market. Just on that particular issue, in terms of pricing of insurance, I thought I'd just briefly highlight some of the significant risk factors that happened and the risk reward. So by risk reward, I mean this. When we're looking at any person entering into a building or construction project, everybody does it to make money. We don't do it for the good of our health. But as the La Crosse decision found, sometimes the parties that are paid or receive less in terms of a recompense for their various efforts from a professional perspective may also find that they have an inverse risk, what we call a misreward in terms of the damages that they may face. If it's ultimately found, as they found in La Crosse, that they had failed to reasonably comply with their contractual obligations. For example, the builder, Ilyu Simon, had a fee of $96 million to build the building. It ultimately was found to bear zero responsibility in terms of responsibility for the damages. The architect, fees of $2.66 million, ultimately found to be 25% responsible. The superintendent was found to be responsible. They had significant fees, but they had a zero apportionment. The last two parties, however, the building surveyor and the fire engineer, both had relatively minor fees compared to the significant fees generated by the builder and the architect respectively. So, for example, the building surveyor had fees of approximately $100,000. They were ultimately found to be responsible for 33% of the damages payable. The fire engineer, even worse, in terms of the risk reward, 39% apportionment of the ultimate damages of $5.7 million, but their fees were $33,000. The point behind this is this: there needs to be a real consideration for understanding whether the fees that we generate if we tender for a job are going to match the potential risk that we face if we get it wrong. As Lacrosse found, the surveyor and the engineer, for example, had failed to carry out due diligence in terms of the work that they were doing. The fire engineer could have, by reasonable inquiry, it was found by Judge Woodward, discovered that the aluminium composite panelling, which was ultimately chosen and installed, did not comply with the then known Building Code of Australia. The building surveyor was also found to be similarly liable and was found to had failed to exercise reasonable care in the performance of its duties. One has to say that for a relatively small recompense, their ultimate liability was considerably greater in terms of the ultimate damages. That judgment may not stay as it is, but I'd have to say to you that Lacrosse serves as a warning not only for design building practitioners but also for the insurance market to understand the risk that one takes. How can one then have to read or consider the pricing of that in terms of issuing policies to these sort of building practitioners, what we call design practitioners, that one would think, based on their small fee reward, might ultimately be responsible in a large setting for significant damages. The last piece of legislation we'll consider is the Residential Apartment Buildings Compliance and Enforcement Powers. So in terms of the first legislation, deals with active registration, compliance and enforcement, and sets out a framework for recovery and a duty of care owed to landowners. The Residential Apartment Buildings Enforcement Act really makes provision for active involvement of the inspectors at an early stage, well before the completion of the building, to investigate serious defects and take various action, which will include compliance issues, investigations and entry on premises and rectification orders. The Act specifically applies to breach of major defects, so serious defects. We're talking about building products or building elements, or where those defects render the building unable or unfit to be occupied, or where there's a threat of collapse. So again, adopting the legislation in the Home Building Act in terms of what a building element is, in terms of the Design Practitioners Act, in terms of understanding what a serious defect is, it's got to be serious. The duty is owed by a developer. That is spelled out to be a person that is the owner of the land. Can also be a principal contractor, where you have more than one contractor that's responsible for the building work itself. Building work is set out in the Act, but will also include design work. The Act will only apply to residential apartment buildings, Class 2 buildings, but it also will allow or permit an investigation going back 10 years, whether or not the building has received a construction certificate or a complying development certificate. So this is the real killer with this Act, that enables active enforcement and investigation by the Department of Customer Service to investigate building defects. The Act also makes provision for another key issue, which will allow the department to prevent or revoke the issue of an occupation certificate and or the registration of a strata plan. Now, we said earlier that part of the problem with the industry in New South Wales and Australia has been that typically after the sale of the plan of buildings, the building is sold after the issue of the occupation certificate. At that point, after the money is guaranteed or collected, the developer suddenly disappears. What this Act then seeks to do is to stop that. to say that before the issue of an occupation certificate, the developer or builder will need to apply to the department for an issue of an occupation certificate. They will need to do that at least 6 months before they are asking the occupation certificate to be granted. This will permit this investigation by the department to understand whether there's the building works have been carried out. It will also prevent, as I said, the registration of the strata plan. Now, if the department finds out or makes an assessment based on its investigations that the work has not been completed in accordance with the relevant standards, it can issue an order which mandates that those work to be done, what we call a remedial rectification order. The span of that order will be until the work is done, and or the passage of 12 months after the issue of the order. It will also permit the work to be done by the department if, for example, the developer, having received the notice, does not comply with the order. The Act also sets out a system of framework of natural justice, so that will permit a developer to contest the findings of a remedial order or investigations, and those appeals will have to be lodged within 30 days of the issue of an order. They can be contested by the developer through the Land and Environment Court. So this piece of legislation, while I'm giving it less coverage today in terms of time, it's no less an important piece of legislation because of its potentially retrospective nature in terms of permitting investigations for work which have been already completed, whether or not the construction certificate and or compliant development certificate has been issued. It will also mean that we have a rectification order. As I said, it may permit, it will be allow the department to place notice of that order to a certifier, to a local council, and or to the Registrar General. The significance of those developments is that a potential purchaser is enabled through its solicitor or conveyancer pre-settlement to understand whether a rectification order has been issued and complied with. And if that has not been done, then I would imagine the careful purchaser would probably not complete or would do so on terms which required the work to be done before settlement. Again, I think that's a key part of the legislation in terms of providing active enforcement, active investigation, and a signpost to potential purchasers that there may be issues with the building that has been maybe purchased. My last slide just deals with a possible snapshot into what the future of the construction and building industry in New South Wales may look like in terms of government response. On the 30th of April this year, the New South Wales Public Accountability Committee, which is formed as part of the Legislative Council, issued a series of 22 recommendations for what it would like to see in terms of the future of the building industry. I don't need to go through all of these, but merely summarise increased powers to the Building Commissioner. I'm certain that with 75 members on his staff, David Chandler will be and continues to be busy and will no doubt continue to investigate issues. Issues dealing with flammable cladding. In New South Wales presently, there's no provision for a government or a public funded cladding expose. In Victoria, on the other hand, they have a system of mandatory public funding, and they've set up a regime already and have called and awarded tenders in relation to fixing or remediating defective cladding. Remains to be seen whether a similar provision is agreed in New South Wales. The government will publish criteria regarding classifying buildings. So if this happens, then that will enable any potential purchaser of a building to go straight to the website to find out if the unit or the building which has been the subject of a purchase has been issued with an order and whether that's been complied with. There will also be a recommendation by the Committee for Mandatory Testing by NATA. There will also be, this is an important one, amending the Environmental Planning and Assessment Act to have a mandatory inspection 2 years post the development consent being issued. Now, again, if that happens, what that will do is to bring to a head potential issues of building defect or defects in design at an earlier stage than might otherwise be discovered. That said, I'd have to say to you that when looking at mandatory testing and inspection, oftentimes these major issues such as waterproofing and fire safety might not become apparent until at least the second or third year post-occupation or construction completion. The last recommendation relates to the appointment of a strata commissioner. I think that's probably one that may well occur in any event. That's to try to make provision for a greater regime of for affected strata homeowners where you have major defects and in the absence of statutory home warranty insurance. The last point I'd say to you is that both the pieces of legislation which are covered today make provision for the New South Wales Legislative Council Public Accountability Committee to prepare a report in response to these two pieces of legislation by March 2022, and then to prepare their further review and commentary by June 2022. So what that means is that I'm certain that you will have continuing review of the ongoing, probably how these new pieces of legislation have worked in practice relating to compliance, declaration and insurance. And I'd have to say to you that the effective operation of these two pieces of legislation will only be truly known if there is some ongoing talks with the Insurance Council of Australia to try to provide a clear way of ensuring that current levels of professional indemnity insurance and other insurance available for design and building practitioners are put in place so that the risk that they face is also adequately catered for in the policy in terms of them being able to claim on their policy if it's found that there's a claim being made on their policy. I think that's all there was. Thank you for your time today.